Assalamualaikum warahmatullahi wabarakatuh. My name is Fadli Rizki Ramadhan. This video was made to fulfill on of the course tax and English course Miss Dr. Evi Purwanti SH LLM. Legal English. Legal English is used by legal expert as well as legal practitioner with the respect to the scope their work in law. Present of English law or legal English with the language style or language model or a distinctive style, which is often different from the language English in general, can be recognized and read through writing on various topics in the field of law. Both aspects of criminal, civil, business, state administration, as well as internationally confined in legal journal as well as various literature or book on law. In addition, the existence of legal terms is also very easy to recognize in writing on various laws. Treaties international such as treaties and convention, contract, decision, court, as well as legal recommendation. Legal English often has a different style, different of English in general, even by non-skilled reader work in the field of law or legal expertise. Often this type of language is considered difficult to learn. The difference and peculiarities that exist in legal English are sourced from and influenced by the language used in law, French, and Latin. Legal English was originally used by legal experts in English-speaking countries whose legal system is subject to the tradition of the common law system, such as in America, England, Canada, Australia, and New Zealand. Indeed, at first, the English used was English for British people in general. But since the Normandy invasion of England in 1066, it is realized that English or General English is the language of poor people mostly in England, while the Anglo-Norman French, which is sourced from French, and Latin is considered the official language for learning, especially the official language for government and law. In this regard, why English law or legal English is different from English in general and the many derived terminology from French and Latin law disumpai in English law. Remembering legal English in some things have their own characteristics that are influenced by language is in French and Latin law. Then, to be able to know the meaning of the phrases in legal English on alternative is to read writing on legal topic both in the legal literature as well as legal document. Increasingly reading and studying legal topic in literature, journal, and legal document, the easier it is to understand about what is meant by process or legal terms. The null and void is a real legal terms. Both the word null and void both mean no have legal effect or non-binding. However, in it use the pairs null and void is always used together, so when compared with English in general, the existence of the pairs null and void look odd or unusual. That's legal English influenced by French and Latin, so making it sometimes bit difficult to understand. Precise null and void is general use the legal field agreement. The legal requirement for an agreement in Indonesia are regulated in Article 1320 of the Civil Code According to the article, the agreement it becomes valid if it fulfills 4 conditions. Number 1, agree those who bind themselves. Number 2, the ability to make a engagement. Number 3, a certain thing. Number 4, a lawful choice. Condition number 1 and 2 are subjective terms. If falls on one of these conditions is not met, then the agreement can cancel it or voidable. Meanwhile, condition 3 and 4 are subjective conditions. If one of the conditions is not met, then the agreement becomes null and void, or also called void or void ab initio. In an agreement, if for something the reason the agreement was declared null and void, that means the agreement is non-binding and cannot be enforced effect by the parties. Patent and royalty, a legal terms of art, is a purse that has a certain and definite legal meaning that cannot be replaced by other words. As an example, patent or Indonesia patent is a legal terminology regarding exclusive right owned by the inventor relates to his invention in the field technology, both process and product that contain element of novelty, inventive and applicable step in industry. Human intellectual work that is not in the form of invention in technology like work of art or not may be referred to as a patent, because the terminology patent only form for inventions in the field of the technology. If work of art the called copyright. Royalty is a compensation in the form of payment for the use and ownership. Generally, royalty is related to the use of property right, intellectual property such as patents or copyright. In a license patent, the party granted the license to use the mandatory patent pay a royalty fee in the form of a sum of money to the owner patent according to the agreement between them. So that was my presentation about legal English. Thanks for watching. Assalamualaikum warahmatullahi wabarakatuh.